Now, in this session, essentially I want to cover three things. First, to give you a general introduction to concepts of insolvency and creditor protection. And as part of that, towards the end of that bit of it, I'll just mention some conflict of laws issues as well, which you've always got to have in your mind in this area. English lawyers, when I trained, English lawyers almost ignored the fact that there was the rest of the world, mainly because most of it at some stage had been owned by England, so they just went along with what we said. Well, sadly, those days have long since passed. So you always need to have in the back of your mind when you're thinking about these issues the fact that different jurisdictions approach things differently. So whilst the English law way of analysing problems and solving them, if it can, is one way, that may not necessarily apply elsewhere. And so we do need, just towards the end of this, after we've gone through all these things, just to sort of come back to the conflict of laws points. Then I want to talk to you more specifically about concepts of secure transactions in English law. The ways that English law allows security to be taken, what it means, what its consequences are, and so on. So at that point, we've ditched conflict of laws, and we're just assuming that everybody follows the English model, which of course I've already told you is not going to be the case. And then thirdly, if we've got time, I'd like to spend as much of the last bit of this session as possible talking to you about insolvency regimes, the particular insolvency regimes that apply in English law. And the particular relevance, I hope, of that for you will be that when you're looking at an English law loan agreement, it might explain what the insolvency clause in the event of default is all about, and why it goes on and on and on with different things which you might think are all saying the same idea. Right, so then just, everyone's got the notes, I assume, have they? Is that a, yep? Oh, Raphael, have you fallen down on handing out the notes?
They are. I sent them by you, but I'll put them up on the course website as well.
Okay. Well, just imagine if you haven't got them. Imagine that you've got the notes in front of you. Right. Insolvency. Let's just start thinking about the players in an insolvency, and there are two sets of them. There is the debtor, the chap who owes the money and hasn't paid, and on the other side is the creditor or creditors who are owed the money and haven't been paid. And it's, as we'll see, it's normally a pretty ugly situation for everybody. Now, debtors to start with. Essentially, there are two types. There are corporate debtors and there are individuals. I'm not terribly interested in individuals, but just to make this point that the regimes are slightly different depending on whether you're dealing with corporate debtor or an individual as a debtor. Where there may be some overlap is, for instance, with a partnership. True partnership in English law, not talking about limited liability partnerships, I'm talking about true partnerships, will usually be a collection of individuals, hopefully all flying in the same direction. In my experience, that isn't always the case. And when a partnership goes bust, you're talking about a whole set of individual insolvencies of the individuals. But We haven't got time to worry too much about that. So let's concentrate on corporates as debtors. And then that brings us really to the first important point, which is that when you're looking at a corporate debtor, the basic principle of company law, you must distinguish between the corporate entity and its shareholders. Now, what's the English law case that says that? It's 120 years old. Salomon and Salomon. Yeah. House of Lords decision. Can you remember how many judges in the House of Lords decided in favour of the principle that we now regard as the basic principle of English company law, and how many decided against it? I'll give you a start. There were 5 of them. So how many judges decided in favour of the principle that we now say is the fundamental principle of English law? 3, yeah. So it was only decided 3-2 that a company is distinct from its shareholders. But that's the principle. So that means that the company's assets are the company's assets, not the shareholders' assets. And the company's liabilities are the company's liabilities and not those of the shareholders, the so-called corporate veil. Now that's all pretty basic stuff, but at various points I'll refer to a recent example of the importance of that, and it's Lehman Brothers. The Lehman Brothers group, when it went spectacularly bust in 2008, involved over 100 different corporate entities. And a huge amount of time and not a little bit of money has been spent on trying to unravel who owned what and who owed what to whom. And it wasn't just a question of which entity owed what money to which external debtor, but there were also questions of intercorporate debt between all the members of the group, and all of that had to be unravelled before the Lehman Brothers insolvency as a group could be worked through. One of the great things about English insolvency law is that every sort of 10 to 15 years or so someone goes completely bust. And it's worth fighting out the consequences of that. And that leads to vast amounts of interesting law. So, for instance, in the early 90s, an outfit called Bank of Credit and Commerce International went bust. And that led to BCCI numbers sort of 1 to 100. And at various points along there, the case gets all the way up to the House of Lords, as it then was, and some very important point gets decided. And we've seen the same with Lehman Brothers. So, people going bust is good news for lawyers. From an academic perspective, it gives us a whole lot of interesting law, and from a practical perspective, it makes us all rich. So, there is hope. Now, I also just want to mention that there is one category of debtor where we may need to think about slightly different rules to ordinary corporate debtors, and that is banks and, to perhaps a larger extent, financial services outfits. And again, the sort of this financial crisis that we're not quite through yet has demonstrated the need for a whole set of special insolvency rules to deal with those sorts of people. And there are 2 basic reasons for that. One, because you and I put our money into banks, and we do so in the fond expectation that we'll get it back. And the second point is that banks are crucial to the general functioning of the economy. So if they go bust, and again Lehman Brothers is a good example of that, then you have all sorts of knock-on economic problems with flows of money and all the rest of it. So it is necessary with banks to have some special regimes and special rules, and that's now been demonstrated. Until this crisis, essentially, the insolvency rules in English law for banks were the same as for everybody else. You just treated them as if they were an ordinary corporation. And it became rapidly apparent that you can't do that any longer, and so the Banking Act of 2009 got passed, which introduced some special insolvency regimes for banks and building societies. Right, so we've looked now at sort of debtors and such like. Let's think now about the creditor side of this equation. And there are both commercial considerations here and also some legal implications related to who may or may not be a creditor. Commercial considerations first. It's generally true that in an insolvency, creditors who are banks or financial institutions or something of that ilk can act much more quickly and will act much more quickly to try and preserve their position, as opposed to ordinary general creditors, people who supply goods and services. So the guys who are likely to pull the plug are the finance creditors rather than the trade creditors. And there's one particular type of finance creditor that's come to the fore again in this crisis, but one had seen them earlier. And that are the so-called specialist debt funds, the vulture funds. And the most famous of all of those is a lot called Elliott Associates, which is a sort of New York-based hedge fund, which specializes basically in buying up distressed debt and then causing merry havoc. And anyone here from Argentina? No one from Argentina? Well, if you had come from Argentina, you would know all about the problems that Elliott had caused with all the Argentinian government debt. From a legal perspective, the identity of the creditor may be important because some types of creditor are given a preferred status in an insolvency. Generally speaking, if you go around the world and you ask, well, who falls into that, who would normally be the first one you would think of? Someone who gets a special status as a creditor in an insolvency.
Employees of their salaries?
Yeah, employees, yeah.
Taxes?
Sorry?
Taxes?
Taxes, yeah, the tax man. The state, yeah.
The IMF.
The IMF, yeah, if you're talking about country debt. Now, there's nothing which says that countries must pay off the IMF first, but if you don't get any more money. But the state, the tax man in particular, go around the world, he's normally sort of ranking up there pretty high amongst everybody who gets paid out. Does that apply in the UK? No, we gave it up. The state gave up its preferred status in insolvencies back in the mid-80s, and it got rid of the final bit of it at the beginning of this century. So curiously enough, the taxman does not have a special preferred status in insolvency law in the UK, which is odd, at least by historical standards. But there we are. So in fact, in that category are very, very few people. employees for 8 weeks of unpaid wages and associated holiday pay, a very, very little bit of unpaid social security contributions, and that's about it. Right, so we've now looked at the players. Let's now think about concepts of default and what happens when things go wrong. Now, here I'm talking about financial default. English law distinguishes between default in terms of paying a sum due, a debt, from ordinary contractual default. What's the remedy for ordinary contractual default? What do you have to do? You sue, don't you? You sue for damages. Occasionally, and I underline that word occasionally, you may get an order for specific performance, say, by which the court says, go and do what you promised to do. That is actually quite rare. Mostly, you're left to getting an order for damages. So, 2 or 3 years down the track, you manage to convince a judge what your damages are, and that involves proving the loss you've suffered. And you may actually have suffered no loss. And only at that point, when you've got a judgment awarding you damages and the damages have been assessed, are you then in the position of being owed a debt. Whereas if it started off as a debt, an amount due, then your remedy is immediately to claim the amount due, and the consequences of that will then flow. So thinking about that in terms of finance, when we're thinking about debtor default, we might be thinking about actual default in payment of either principal or interest when it's due on its due date, or a manufactured situation. Now, how do we manufacture that an amount payable is now due? What's the clause in the loan agreement that does that for us? It's the events of default clause, isn't it? You all familiar with an events of default clause? Yeah? It's a sort of long list of everything that you could possibly imagine that might go wrong. And if any of those things goes wrong, then essentially the lenders have the right to pull the plug and say, okay, you thought you'd borrowed this money for the next 10 years, but hey presto, it's now all due and payable. Don't be misled by that expression default in events of default. Some things are defaults, yes, they haven't done what they're meant to have done, but other things may not be of that nature. But they are events that the parties have agreed, if they occur, will give the creditor the right to say, all bets are off, I want my money back. An example I used to give in the sort of early part of the 1990s when illustrating that was, you could put into your events of default clause anything you like. And the example I gave was that the Prince of Wales decided to make an honest woman of Camilla Parker Bowles. Well, lo and behold, it happened, and I'm not aware of anybody calling an event of default as a consequence of that. But, it could be that ridiculous. So a practical thing for you as lawyers in the future is look at it carefully and make sure that what's there bears some relevance to the transaction in which you are then engaged. And the other funny thing, by the way, about events of default, just while we're talking about it, is that any one of them will do. And there's a bit of law on all of that now, that first you don't read them all justum generis, so you actually look at each clause and work out what it means in its own wording. And the other thing that the judges have managed to hold is that as long as an event of default has occurred, even though you may have specified the wrong one in your demand for repayment, it doesn't matter. All you've got to show is that an event of default did actually occur. And then the consequences of that, and I'm sure sometime have a look at the clause, but essentially what happens then is the lender's got the right to demand repayment on demand. And in English law, as it stands at the moment, if you've got a right to demand repayment on demand, that's what it means. You've got about an hour if the demand's made in business hours. So it's pretty drastic. What's the most common form of on-demand lending in English law? Overdraft, yeah. Don't need long, fancy documents to establish an overdraft. It's normally about half a page. And basically, the principle of an overdraft is that it's repayable whenever the lender wants his money back. He doesn't have to give any grounds for that. It could simply be that the bank manager rolled out of bed and had a bad headache and thought, I'm going to take it out on all my customers. And essentially the same result happens when an event of default is triggered and the lender gives notice. That then essentially turns it into an on-demand loan, and he can have his money back whenever he wants. So assume that, one way or the other, the money is now repayable and the debtor doesn't pay. Might be a miracle. I mean, it doesn't happen. I've never ever seen a borrower able to repay when an event of default has been called. But terrific if they can, but unlikely. So one way or the other, the creditor has not been paid when he was entitled to be paid. What follows? Well, essentially we're now thinking about enforcement, aren't we? Litigation. You sue for the debt. And there's a fairly quick, fast-track procedure to get judgment. If you can establish that you are owed the money, then you'll get judgment pretty promptly, within a couple of months. You're still not paid. Now, leaving to one side for the moment whether you have security, assuming you don't, so you're an unsecured creditor and you're now the proud holder of a judgment with a nice big red seal on it from the Royal Courts of Justice. So what? That won't mean you get paid either. So if they don't pay you, you can then go back to court and say, we haven't been paid, we're most upset about this. Terrible business, haven't been paid. Please give us an order of execution against assets of the debtor. So by doing that and getting the order of execution, you then turn your unsecured debt into a debt secured by those assets over which you now have an order of execution. And that then essentially makes you a secured creditor. So we then get on to enforcement of security, either because you are enforcing your order of execution or because you had security in the first place and you are now enforcing the security for payment of the debt. And then the final bit, if either there are no assets that you've been able to satisfy the debt from, or there were but they weren't sufficient, then the final bit is insolvency proceedings. Now, what do we mean by the concept of insolvency? Well, in English law, you'll find it all set out in sections 122 and 123 of the Insolvency Act of 1986. But the basic idea of insolvency, and this really applies wherever you go, is an inability to pay debts. So you have to prove that there is an inability of the debtor to pay its debts. And that in turn breaks down into two separate concepts. There's the immediate cash flow deficiency. In other words, they don't have the ready money now to pay the debts due now. And just put inverted commas around that word now for the minute. It's not actually that at all, but that will do for the second. And the alternative test is essentially excess of liabilities over available assets. Now, if you think about the aristocracy for a minute, they're normally bust on the first of those. They've run out of ready cash, but they've got the great pile down the road, but they can't sell it. So they've got the assets, so they're covered on the asset test, but they haven't got the money to pay their gambling debts or whatever it happens to be. Now, I did say, that word now is not quite now, and the question is, on the first of those tests, the cash flow test, how far into the future should you be looking to see whether there is money to pay? And the courts have said you can project forward for a reasonable period. So it's not just the money due on the 4th of March, but maybe what's due the rest of this week and going into the foreseeing weeks. And on the so-called balance sheet test, if you actually look at subsection 2 of section 123, you'll see it says, taking into account prospective and contingent liabilities. So it's not actually a balance sheet test at all, because in accounting terms, what you take into account on the balance sheet, for instance, in relation to contingent liabilities, is very different from what we're talking about here. In accounting terms, you only include the contingent liabilities in the balance sheet as liabilities if they are about to become actual. In other words, there's no way out, they're going to have to be paid. What's the most common type of contingent liability? Yep. No. Guarantees, yeah. If you think about a guarantee, you're on the hook if the primary debtor doesn't pay. But until he doesn't pay, you're not on the hook to make actual payment. And if he meets his obligations, you never will have to do so. So that's the most common form of contingent liability. I guess insurers would show on their balance sheets the risk of claims before the claims have been made. So, prudent actuarial study in insurance accounting would probably require something there to be included. But for our purposes here, we have to take account, and the question is, God knows how, of contingent and prospective liabilities. Now, prospective liabilities is easy. That is things we know will have to be paid in the future. What we don't know is how you discount that back to present day values. How you take account of contingent liabilities in this test, I don't know. I mean, let me give you a good example. If you took account in this test of each and every possible contingent liability, then on that test, every bank in the world is bust, because banks issue guarantees. Of course, they hope that they won't all get called. But if you were to have to take into account each and every one, then every bank in the world would be bust. And that can't be right. Well, perhaps they are. Now, I've given you a little case there, not so little actually, quite long, in the Supreme Court, the BNY corporate trustee case, if you're interested in looking at that in more detail. That's the most recent pronouncement on those two tests. Right, so we've looked at the concept of insolvency. Now the question, what's the relevance? Well, as I say in the notes, it may or may not lead to insolvency proceedings. doesn't necessarily, not all people who are insolvent go into insolvency proceedings. You may get bailed out. I'm sure most of you have experienced that very generous gifts from mum and dad bail you out. Or the creditors just may not do anything. Wishful thinking, really. But being insolvent is the most important preliminary step to insolvency proceedings being commenced. As I say, it's also a reference point for recapturing assets. Now, I'm thinking here, again in relation to the Insolvency Act, the two principal sections for our purposes are section 238 and 239 of the Insolvency Act. 238 is transactions at an undervalue. And if one of those has happened in a relevant period before the entity went into insolvency proceedings, then the insolvency practitioner can try and recapture assets that were disposed of in that period. And it is only a relevant period if the debtor was insolvent at the time. So debtor's gone bust today. The insolvency practitioner can look back 2 years to see everything that's gone on, what less than full value transactions happened. He can seek to recapture the assets or the money or whatever, but only if, when it happened, the debtor was in a state of insolvency or became so because of the transaction. Classic example. Companies in difficult times, and the directors realise that and say, well, we've got what we think is a nice little business here, so we'll just transfer all the assets out of our company into our new company and let the old company disappear, and we'll carry on with the new company. Classic example of a transaction at an undervalue, because you can bet your bottom dollar that the assets would not have been transferred at full value. And so the insolvency practitioner can say, hang on a minute, I want those assets back. 239 is preferences. And essentially a preference is where someone who is a creditor was paid off ahead of the other creditors in the vulnerable period, which in most cases is 6 months before the commencement of the insolvency proceedings. So you owe money to mum and dad, you realise you're about to go bust, and for the first time in your life, natural affection takes over and you decide that they ought to be repaid. So you repay them and all your other creditors are left lamenting. Well, bad luck, the trustee in bankruptcy can come after you, or go after your parents and get back the money that you gave them. Another example, you realise that things are looking a bit dodgy, and for some reason or other you have a creditor that you like, and so you give them security so that if you do go bust, they can rely on the security. So a state of insolvency is relevant to both of those things, so we need to think about the tests in that. By the way, it's also relevant, I haven't put it in your notes, to misfeasance proceedings, wrongful trading, that sort of thing. If you're a director of a company and you carry on trading when you know that the only certain outcome is that the company's going to go bust, then under Section 213 and Section 214 of the Insolvency Act, the liquidator can come after you personally, saying you shouldn't have done it. And then we see it in transactional documents, and one of the events of default clause is always going to deal with insolvency. So being in a state, being insolvent and or in insolvency proceedings will be an event of default. Have you looked at the ISDA documents, Raphael? No. Right, insolvency proceedings. We will spend a bit more time on all this later, so just some general points at this stage. The types of insolvency proceedings. For individuals, essentially you go bankrupt. And an insolvency practitioner called the trustee in bankruptcy is appointed, and the trustee takes charge of all of your assets and essentially sells them off to try and raise money for paying off the creditors. And after a period of time, you sail out of it freed of all your previous debts and into the big wide world so that you can do it all over again. The roughly equivalent of that for companies is called liquidation or winding up. They mean the same thing. But the difference is now that it leads to the death of the company. The ultimate outcome of liquidation or winding up is dissolution of the company. Once the liquidator, who is the insolvency practitioner, has got in, realised all the assets to the extent that there's money paid off the creditors, so that there's nothing left, then that's the end of it. The company is dissolved and ceases to exist. Now, 500 years ago, we might have thought about doing the same with individual debtors, but we don't do that any longer. The alternative to these awful things is some form of reorganisation, in the fond hope that the debtor can be sort of stabilised and live to fight another day. In US bankruptcy law, that's called Chapter 11 bankruptcy proceedings. Here, the principal type of that proceeding is called administration. The philosophy behind that is that liquidation is not always the best thing that can happen. There may be a better hope to try and stabilise the situation, get the business back under control, come to some managed arrangement with creditors so that the business can survive and the creditors get more than they would in the fire sale that takes place in a liquidation. That's the theory. It, I'm afraid, doesn't usually work out so well. The position of unsecured creditors in insolvency proceedings, as I say in your notes, is essentially one of the equal sharing of pain. Once insolvency proceedings have been commenced, I'm thinking particularly here liquidation or bankruptcy, then your claim as it is ceases to be enforceable, and instead you get a right to prove in the insolvency for your debt. So essentially what's happening here is your individual right as a creditor to enforce for payment ceases. And instead, you get tipped into the pool with all the other creditors, and you are represented by the insolvency practitioner, who then attempts to do his or her best on behalf of the creditors as a whole. And the insolvency practitioner then realizes the assets, the available assets, what I call the free assets, for the benefit of the general body of unsecured creditors. And they each get what is called a dividend. And the easiest way of explaining that is assume assets of 10 and a total of all the debts of 100, then each creditor gets 1/10 of their debt back. Now, actually, if you get 1/10 back in an unsecured liquidation, you're doing pretty well. You're more likely to get 2p in the pound, something like that. So it's bad news. There are one or two creditors, and we've already referred to these, who rank ahead of the general body, and they may be the ones who have a preferred position as a matter of law. We've spoken about those, and the others, of course, are those who hold security. So let's just very quickly think about some general concepts of security. The old joke that used to be told is that a banker dies and goes to heaven and realizes that he's in London. It gives you a sort of general flavour of the English law approach to security. Basically, secured creditors are kings. And if you go back 200 or 300 years and read all the case law, you just see the judges bending over backwards to find in favour of security holders. And that position pretty much continues even to the present day, with one or two statutory limits now, particularly in relation to the consequence of administration. But as a general proposition, and if you want to look this up, you have a look at Lord Millett's speech in a case called Buckler and Talbot, which is 2004 UKHL, United Kingdom House of Lords, case number 9, or 2004 Appeal Cases 298. And essentially what Lord Millett said was this, that when you're looking at the assets of a debtor, then those assets are only the assets in which others don't have a proprietary interest. So the consequence of a creditor holding security in an asset is to remove it from the debtor's available assets in an insolvency. And therefore, the unsecured creditors are only entitled to what's left after the secured creditors have exercised their security over the secured assets. So there's not much pickings normally for the unsecured creditors. And essentially what that's doing, therefore, is assume that the debtor had given security to various secured creditors, and let's assume that that's amounts to all of the debtor's assets, then the unsecured creditor's claim is only in what's left, represented in legal terms by a concept called the debtor's equity of redemption. What the debtor has left in those secured assets after the secured creditors have taken all that is necessary to pay them out. And that's the debtor's equity of redemption in what's left. So, the main reason, therefore, for a creditor taking security is to protect himself in the debtor's insolvency. There are other reasons which I've just listed for you. First, and it's a very important thing to remember this, that a creditor can enforce his security whether the debtor's in a state of insolvency or not in a state of insolvency. If I've borrowed money from my bank to go and buy a house, and so I've given a mortgage over the house to the bank as security, and I don't pay my mortgage, the bank can clear me out of my house and sell it, whether or not I've gone bankrupt. Now, the only limit really on that now, again, is if the debtor's gone into administration, at which point, as we'll see later, a freeze has gone to stop that type of creditor action. But outside that, the creditor is free to enforce so long as the conditions for enforcement have arisen, which may or may not be in the context of insolvency. Chances are insolvency is going to be hovering around simply because if the debtor can't pay, then it looks like he's bust. You might take security just to stop others doing it. To say, well, you know, I'm buggered if I'm going to be an unsecured creditor if Bloggs down the road's going to grab a mortgage over the debtor's assets. So to stop that, you take security yourself. And particularly there, you might have in mind also execution creditors. So somebody who starts off as an unsecured creditor, to stop them gaining a march, you have your security there and you will rank ahead of the execution creditors. Getting a little bit more technical for a minute, in securities and derivatives transactions, it's often necessary for the parties to provide security to cover their outstanding positions. And that may be highly relevant, for instance, in thinking about credit limits. So if Bank A is dealing with Bank B in some securities transaction, and in effect, Bank A has provided credit to Bank B, then Bank A may well want from B some form of security over assets of B, maybe the securities that have been bought, to make sure that B will repay Bank A. You find that quite often in derivatives transactions as well. For regulatory reasons, it may be a very good idea for a bank which is providing credit to hold security. Now, have you dealt, Raphael, with capital adequacy and that sort of thing?
What's that?
Capital adequacy?
No.
Okay. Okay, we're just going to, you can all sort of wake up when I tell you it now. We're just going into a little bit of regulation for a second about banks. There are rules which are pretty much worldwide. They're called the Basel Rules. About trying to make sure that banks have enough capital to withstand losses in their business. And the idea behind that, of course, is to make sure that the banks can themselves meet their own engagements to you and me as depositors. So if you just think in company law terms for a minute, let's sort of just run through the order of payment. Creditors get paid ahead of shareholders. Yep. So capital adequacy is essentially about making sure that there is enough money provided by the shareholders so that the creditors come out before the shareholders. So there is making sure that there is a capital buffer sitting in the bank's books to withstand the initial shock before we need to start thinking about selling the bank's assets. And the Basel rules say essentially how much capital there should be, and it's measured against the risk to the bank in its business. Now, if you think about it, what is the risk to a bank in its business? What's the main risk, other than the chairman buggering off to South America? Essentially, that the borrowers don't repay, yeah? Because you think about a bank's balance sheet, in the assets side, what are the assets? Well, there's a chairman's jag or whatever, but ignore that. Its assets is money lent, isn't it? It's the claims the bank's got to repayment by its borrowers. And the risk to the bank is that those borrowers don't repay. So to make sure that the creditors of the bank, who essentially put up the money that the bank lends on, to try and make sure that those creditors get repaid, we need to make sure that there's a buffer there, which is share capital. So the question then becomes, how much in percentage terms should there be of share capital compared to banks' assets? And the basic rule that they came up with in the original sort of Basel deals, and we're now up to Basel III, but so Basel 1 and 2 was a figure of 8%. So for every £100 the bank lent, £8 of share capital. But then some bright spark said, well, of course it's not sort of that simple, never is of course, because if you're looking at that £100 that I've just mentioned, some of those loans inherently will be riskier than others. And the less risky ones will be the ones where there is security that the bank's got, because it can look to the security if the borrower doesn't repay it. So instead of saying that every £100 lent to every borrower is treated as £100, where the bank's holding security, then we ought to say that the risk associated with that loan is not the full 100, but the real risk once the security has been taken into account. Everyone following me? Yeah. So that's a very good reason for banks to hold security, because it reduces the capital adequacy consequences of their business, and it means therefore they don't have to hold as much shareholders' funds as before. And that inherently means therefore there's more dividends payable to the shareholders because there's fewer of them. And of course that wonderful system was exposed for what it really is in this recent financial crisis. Because it suddenly turned out that, whereas we all thought it was 8%, it was actually getting down once they'd mucked around a bit and all sorts of intricate little deals here. It was sort of down with some of them at 2 and 3%, and they got wiped out. And that's not a good idea. So the UK government now, for instance, is talking about 17% for the important banks in the UK economy. And they're all moaning like hell because that makes them less profitable. And perhaps I might just also explain that not only was there funny business going on in assessing the risk of default in the lending to the borrowers, but there was also funny business going on in working out what was share capital. Now, you and I would understand share capital to be ordinary shares, but all sorts of other things were being taken into account as, well, it's equivalent of share capital, so we'll call that share capital as well, and hence why we get down to our real sort of 2%. If you want a really good example of that, look what happened to all the banks in Ireland. Spectacularly bust. And all the people who were being counted as being equivalent to shareholders were screaming like pigs and saying, no, we're not really shareholders, even though we knew that's what we were being counted as. So that's regulatory stuff, and then obviously the general sort of risk reduction thing. So we've seen why we might want to take security. Then we've got to think, well, okay, what can we take the security over? And that's partly a question of fact and partly a question of law. You can't take security over something that the borrower doesn't own. It's all very well for me to say to the bank, well, I'll give you a mortgage over Blackacre, but if I don't own Blackacre and never will own Blackacre, then that's no good, is it? So there's a question of fact, and later on we'll need to sort of think more carefully about what can we say are assets over which we can take security in a legal sense? And just sort of foreshadowing that a bit. This year's apple crop? Yep. What about next year's apple crop? Doesn't yet exist. I mean, it hasn't even started appearing on my apple tree as blossom yet. Can we, in English law, take security over next year's apple crop? That's a question we'll come back to. So questions of fact and questions of law, one of which is, I've just given you both of those things. But maybe there are some other restrictions as well which say we can't take security. Or maybe we can only take a particular type of security over certain types of asset, and maybe that type of security is not as good as other forms of security we could have. There may be some contractual restrictions, and we may need to think about that. So maybe the borrower has agreed with some other creditor not to give security over its assets, a negative pledge. What's the effect of a negative pledge in English law? Or maybe the security is to be taken over a contractual right, and the contract itself precludes the borrower from giving security over the benefit of its contractual right. I lend you £10, but in our debt contract I agree that I won't use the debt that you owe me as security that I can give to somebody else. Does that stop me doing that, or can my creditor safely ignore that possibility and take that security? And the answer to that will be different depending on which side of the Atlantic you are. English law, being a true, pure system of law, says no. The Americans have a different idea about that. So we've worked out the assets that we can take security over. For what? Do we need to match the security to the liability? In other words, I borrow money from the bank to buy Blackacre, and the bank wants a mortgage over Blackacre to secure that. But could that mortgage not only secure the money the bank's lent me to buy Blackacre, but any other money I might finish up owing the bank? So the difference between security for a specific liability as opposed to security for what we refer to as all monies. And the answer is you can do both. And needless to say, that's what's in the standard form that every bank uses. And it's quite interesting to sort of see the creative inventiveness of English lawyers in relation to everything they can possibly think of that may or may not come out of the woodwork and be secured. It goes on for pages. Usually, security will be an adjunct to the liability of the person giving the security. So it secures my obligation to that creditor, but it doesn't need to. And therefore the security can be non-recourse. In other words, the security is the means of payment. And there's a famous case in 1854 called Matthew and Blackmore that established that. Right, I see we've now done more than an hour, so we'll stop for 5 minutes.